Welcome to HR ListenIn, the free monthly podcast from the employment team at international law firm Taylor Vinters. We hope you enjoy the show.
Hello and welcome to the April 2016 episode of HR ListenIn. My name's Dom Holmes, I'm an employment lawyer at Taylor Vinters and presenter of HR ListenIn. As many of you will know, employment and HR is one of the most heavily regulated areas of law and business practice. And traditionally, the introduction of any new employment legislation proposed by the government often comes in two waves, in April and October each year. Now, 2016 is no exception, and as we're in April, I thought we could have a look at three issues that will have important implications for employers in the coming months. And to help me do that, I'm joined by my Taylor Vinters employment colleague, Scott Glacken. Thanks for joining me, Scott.
Thanks, Dom, and hi, everyone. So the three issues we're going to be covering today are the proposed introduction of gender pay gap reporting, the requirement to publish slavery and human trafficking statements, and the new national living wage.
So quite a range of topics there, Scott, and I think before we look at all of them in detail, perhaps you could outline who will be affected in each case.
Sure, so the national living wage is going to apply to all employees and workers who are aged 25 or over. So it will be relevant to any employer that has staff performing relatively low paid work and or working long hours. Anti-slavery statements will be necessary for any employer with annual turnover of £36 million or more. And gender pay gap reporting will apply to employers with 250 or more employees. And there are quite a few nuances with each of those sort of eligibility requirements, but we'll discuss those later.
So it sounds like the vast majority of employers will be caught by at least one of those changes.
Yes, that's right, and it's easy for these types of obligations to slip through the net amidst all of the other regulatory requirements that are often imposed on employers.
Okay, Scott, well, let's start with gender pay gap reporting, and what's the background to this proposal?
Well, since 1970, equal pay legislation has sought to protect male and female employees' right to receive equal pay for equal work, and that's not changing. But the latest statistics show that there's still a significant imbalance between the average pay for male and female employees across the whole nation's workforce. So on average, male employees currently earn about 20% more than female employees, and this is known as the gender pay gap. And it's likely to reflect a combination of the equal pay issues covered by the existing legislation, but as well a broader issue around gender imbalance in the workplace.
So we've got equal pay legislation, but the government has resolved to do something more about it.
Yes, that's right. So the current position is that the government has recently closed consultation on some draft legislation that's going to require employers with 250 or more employees to publish certain information relating to differences in pay for male and female employees within its workforce. It's due to come into force in October 2016, but there are a few reasons why employers need to be looking at things now.
Okay, and before we come on to those, can you give us a broad outline of the requirements?
Sure. So specifically, employers will be required to publish statistics, mostly expressed as a percentage, showing the gender pay gap within their business. And within these statistics, there's a distinction between pay and bonus pay.
Okay, well, let's take those separately, starting with pay.
Well, pay is fairly broadly defined. It includes not only basic pay, but other payments such as paid leave, maternity pay, car allowances, and quite a few other elements. But it doesn't include overtime pay, expenses, benefits in kind, or redundancy pay. And employers will need to provide the difference between men and women in terms of both mean average pay and median average pay. Separately, employers will also be required to publish the number of men and women in each quartile of their pay distribution. So the quartiles will be labelled A to D, with pay band A containing the 25% lowest paid employees in the company, and pay band D containing the 25% highest paid employees.
Okay, and what about bonus pay?
Yes, to ensure proper transparency, there are also requirements around reporting bonus pay. So bonus pay includes commission, performance-related pay, long-term incentive plans, and also the cash equivalent value of share awards. And employees are going to need to publish the gender pay gap relating to both mean average bonus pay and the number of men and women who receive a bonus.
Okay, so how do employers go about sort of determining those mean and median pay figures?
It will need to be taken from a snapshot of the workforce as at April each year, starting April 2017 and published by the following April. So the first publication deadline is going to be April 2018. But it's important to note that the bonus stats will need to reflect a full 12-month period. The first set of statistics will have to cover bonuses paid between May 2016 and April 2017, and will need to be published along with the mean and median pay information at April 2018. So a point to note now is that employers should ensure that information relating to bonuses paid from May the 1st this year are adequately recorded.
Okay, Scott, so where exactly will the statistics be published?
The pay gap information is going to have to be published on employers' websites in English in a manner accessible to all employees and the public. Employers will also have to retain that information for 3 years and also upload it to a government website. Also, it's important to note that it needs to be signed off personally by a company director or an individual of similar standing in other types of organisations.
So it sounds like a fairly serious obligation, and there must be some penalties for not complying with these requirements.
Well, surprisingly, the draft regulations don't actually impose any civil or criminal penalties whatsoever for non-compliance. Albeit the government has said that it will keep this under review, but it does seem to undermine their commitment to addressing the ongoing gender pay gap issue, which still persists over 45 years after the Equal Pay Act was introduced.
But surely there must be sort of some incentive for employers to do this, Scott. Otherwise, why would they bother if it was just a voluntary scheme in all but name?
Well, the government have indicated that they will publish league tables of certain data, and that employers that fail to report their pay gap information will be named and shamed. So in light of this, the key concerns for many employers is going to be reputational in nature rather than purely to financial exposure, as embarrassing gender pay gap figures could well lead to adverse media coverage and perhaps difficulty in attracting the best talent to an organisation.
So I guess it does have some teeth in that regard. And what should employers be doing now then?
Well, although the regulations are currently only in draft form, it is worth giving some thought to these issues at an early stage. Most importantly, will the gender pay gap reporting requirements apply to your business? That is, will any employing entity within your organisation employ 250 or more employees as at April 2017? And assuming that is the case, there are some practical considerations. How will the relevant data be collected in practice, and will there be a need to introduce new updated systems in order to capture the data in an efficient way?
And I guess presumably a little bit of investigative work now by employers might also help to identify any issues before the publishing becomes mandatory.
Yes, definitely. So, do you know if your organisation has a potentially significant gender pay gap? It may be an issue that you're not aware of, and the published data is likely to be a fairly blunt instrument that does not explain the underlying makeup of the workforce. So employers may wish to consider undertaking a gender pay gap audit now and addressing any obvious disparities before the first snapshot is due in April 2017.
And I guess just to point out, this could be done in conjunction with a legal advisor, so you can attract legal advice privilege on that.
Yes, that's right. This might reduce the risk that the findings are disclosable in any subsequent equal pay or discrimination litigation.
Okay, Scott, so that's gender pay gap reporting, and clearly there is some important groundwork for a lot of employers to do in preparation for those obligations kicking in next year. I wanted to move on now to talk about something which is already in force, but from the conversations I've been having with employers, appears to have kind of slipped in unnoticed.
That's right, this will be the requirement to publish a slavery and human trafficking statement under the Modern Slavery Act.
That's right, and the requirement here is to publish an updated statement for each financial year ending on or after 31st of March 2016. And what this needs to do is explain the steps that an organisation has taken in the previous financial year to ensure that slavery and human trafficking are not taking place within its own business or its supply chains.
Yes, that's right. And as I mentioned earlier in the introduction, the obligation is triggered if a business has an annual turnover of £36 million or more.
Yes, and importantly, that's global annual turnover. So if, for example, a multinational corporation supplies goods or services in the UK and meets the £36 million threshold, even if the size of its UK operation is relatively small, it's likely that this obligation will bite. And I guess in that sense, the Modern Slavery Act has international reach in much the same way as the UK Bribery Act applies to overseas businesses.
And are there any exceptions to this rule then?
Well, possibly, if, for example, an international corporation can demonstrate that the UK subsidiary acts completely independently outside the wider group and of itself does not hit that £36 million turnover. Unfortunately, however, the statutory guidance is not very clear on this point. So, for example, what constitutes complete independence in the UK?
And you mentioned that the business has to explain what checks it's carried out to guard against slavery and human trafficking. So what does the statement actually have to say?
Well, that's a very good question. Again, the legislation gives some guidance, but it's a bit generic. So, for example, a statement can include information about the company's structure, its business, its supply chains, any policies or staff training on slavery and human trafficking, any due diligence processes on slavery and human trafficking and in its business and supply chains, and specifically the steps it's taken to assess and manage the risk of slavery and human trafficking in supply chains or areas of its own business where there's an identifiable risk. So, for example, if a business relies on manufacturing processes or overseas labour from countries with less well-established employment protections, that is certainly something that should be looked at. The Home Office has also published a practical guide to transparency in supply chains that listeners may find useful.
This all sounds quite vague. What are we seeing in practice, Dom?
Well, we've seen anti-slavery statements ranging from a couple of paragraphs long to several pages long. I think if an organisation has been particularly proactive in this area, it will no doubt want to demonstrate that and use it perhaps to promote an ethical brand. Others, I guess, will want to do the bare minimum to jump through the hoops and comply with the legislation, but there's no standard approach as such.
And what if genuinely a company has not taken any steps along these lines?
Well, then it needs to say so in its statement, and obviously that will not show the business in the best light. So, and equally, if the business took steps only part way through the year, the statement should note the time periods in which steps were taken and when they weren't taken.
And I assume that similar to gender pay gap reporting, the statement is going to need to go on the company's website.
Yes, and the rules are quite specific about this. Again, it needs to be approved by the board and signed by a company director, as with gender pay gap reports. Not only must it appear on the company's website, it must be in a prominent place on the homepage. And remember, it's an annual obligation reflecting an ongoing duty to keep an eye on areas of risk each year. So I guess there are some other parallels with gender pay gap reporting, in that there appear to be no financial or other sanctions for not publishing a statement either.
But again, the risk is here just going to be more reputational.
Yes, I mean, in theory, the Secretary of State also has the power to enforce the duty by obtaining a court injunction. And obviously, if you don't comply with a court order, then that may have further sort of punitive implications of its own. In my view, I think it's an obligation that all businesses should be taking seriously, even if the actual risk of slavery or human trafficking within their sector or supply chains is relatively low. And we can obviously help clients with producing a compliant statement.
Finally, I said we would briefly cover off the national living wage, and this is effectively an add-on to the national minimum wage.
Yes, Scott. So the current national minimum wage for workers aged 21 and over is currently £6.70, and lower rates apply to younger workers and apprentices. However, from the 1st of April this year, this figure is increased by 50 pence to £7.20 for workers aged 25 and over. It's been labelled as the national living wage, but is, as you say, in reality just a new age bracket for the national minimum wage.
And workers aged 21 to 24 still get the national minimum wage of £6.70, right?
Yes, that's right. So national minimum wage rates normally change in October each year rather than in April, so we may see an increase in the autumn. And I think it's important not to confuse this national living wage with a separate ongoing campaign by the Living Wage Foundation. Now, this encourages employers to pay a higher hourly wage on a voluntary basis according to the basic cost of living. And the current hourly rates they are suggesting are £9.40 in London and £8.25 elsewhere. So confusingly, this is called the living wage.
And I think it's probably worth mentioning the press coverage that the new national living wage has received in the last few weeks.
Yes, I mean, there's been quite a lot of controversy surrounding it. In particular, there have been various media stories about large organisations who are looking to offset the increased costs of having to bump up basic pay to meet national living wage by reducing other perks and benefits. And particularly some big names in the retail sector appear to be looking to water down or remove certain benefits to reduce the financial impact to them of national living wage obligations. Most of them say that pay structure changes are unrelated to the national living wage, but there's certainly a perception that it is more than just coincidence.
Yes, and the government has fired a warning shot about this type of practice.
Well, yes, that's right. I mean, having trumpeted the national living wage as a real improvement in minimum pay conditions for workers, I mean, there is a danger that this could all be undermined by employers taking away other perks, I mean, some of which are very, very valuable to low-paid workers, in order to pay for national living wage.
But what can they actually do about it? The Chancellor has warned businesses about potential reputational risk, and there's also been talk of putting pressure on them to live up to both legal and moral obligations. But I wonder how much impact that will have.
I think that's a very good point, Scott. I mean, I think without specific legislation to deal with this practice, employers are, of course, perfectly entitled to introduce changes to employment terms, as long as they consult properly and have a good business reason for doing so. Obviously, the best route for that is always to get employee consent, but if that fails, ultimately employers can dismiss and offer re-engagement on the new terms. And if we look at the other end of the spectrum, this kind of narrative doesn't really sit well with the bumpy ride that senior executives are getting from shareholders at AGMs over their own big pay increases.
Yeah, I agree. It sounds like many businesses will need to balance these kinds of reputational issues against the real financial costs of an increased wage bill.
Well, that's about it for this month. Scott, thanks for joining me on this podcast. If you want to find out more about how Taylor Vinters can help you with these or any other employment issues, you can find contact details for Scott and me on the Taylor Vinters website, www.taylorvinters.com. Next month, I'll be joined by another member of the Taylor Vinters employment team to discuss more practical HR issues. You can access all previous editions of this podcast by clicking on the ListenIn icon on our homepage, where there are direct links to the web pages of all of the presenters. And for those of you who are active on social media, you can also find me on LinkedIn and on Twitter at domholmes147. Thank you for listening in to HR Listen In.